Now that we've completed the sentence, we're happy and pleased to put this matter behind us. This August will be 3 years since this occurred, and quite frankly, the county and law enforcement and even the public defender's office, it's enormously taxing to adjudicate a case like this, to go through the litigation process. And we're grateful that it's over. We're mindful of what happened here. I'm pleased with the sentence that was imposed by the judge, quite obviously. We did examine very closely the law as it relates to consecutive versus concurrent sentences to determine whether we could advocate in good faith for a consecutive sentence, and the determination was made that that would be inappropriate here, and so we didn't go there. There was some discussion on the record concerning the lack of motive evidence when the people had to prove intent, and I would like to speak to that for a moment. I had spoken a number of times about motive evidence, that it's not necessary for the people to submit motive evidence in order to prove intent, but that there are times when we do so, and there are times that we determine not to do so. And here we had made the determination quite deliberately not to do so. I'd like to just explain this to you because I think that some justification should be put out there. When this all occurred, back in August of 22, I prepared search warrant applications, and we did go into Mr. Matar's electronic devices that he brought into Chautauqua County and were seized at the time that the event occurred at the institution, and we were able to look into those based upon the legal authority that we got from the search warrant applications, and we were able to start to develop some motive evidence. We then took that and we made contact with New Jersey counterparts, and we developed some additional probable cause to go into Mr. Matar's residence in the state of New Jersey to review other electronic devices and writings and any evidence we may have related to the commission of the crime that occurred here, and we developed further motive evidence. And now all of that was supplied to federal authorities, and at that time the federal government was looking closely at what had occurred here, and they were evaluating the facts and applying it to federal laws, which are quite different than state laws. And because those federal laws are quite different, the expanse of what they could look at if they were to obtain their own search warrant was quite broader than what we could look at. And that's one thing I think is important, because they're in a much better position to evaluate what we can call motive evidence than we are, because here on a state level, we're talking about attempted murder and assault. These are just localized events, whereas federal statutes, the implication of federal law, and at that time it was being investigated, and I believe my understanding is that that investigation has resulted in an indictment. The federal statutes are in a better position to deal with the motive evidence, which obviously has international implications. So we stayed away from that. And we also stayed away from it because we were requested informally to just not go there, so that we wouldn't disrupt the federal process, which went from investigation to prosecution. And then finally, I think it's very important for everyone to recognize that my job is to just to assert the state's case as best as we can, or the people's case as best as we can. And I have to be mindful of potential prejudice, and we have to safeguard Mr. Matar's rights. And the motive evidence here could potentially give rise to prejudicial, prejudice of potential jurors and so forth. So looking at everything, we made a decision conscientiously not to present motive evidence, and we felt, and I think the end result justifies our opinion that we could prove intent without getting into motive evidence. So we have done so. I don't like the fact that it was thrown back in my face, especially in light of the fact that the defense at one time had filed a motion trying to preclude me from going in that direction. But at the same time, and I think it's important to recognize that the defense itself also had a very difficult time at dealing with this fact pattern and the surrounding circumstances and the dynamics in their defense, their vigorous defense, which I thought was a very good defense. And I think Mr. Barone does a very effective job in what he does. And I wouldn't take anything from him because I think that that's a very difficult job. I think each one of us had very difficult jobs, different roles and responsibilities in this process. So I just wanted to address that. I think the only thing I would, say to you is that, and I think I've said this before, 3 years is a long time. It's been a lot. There's been many delays from my perspective. I'm just glad that justice delayed is not justice denied. Mr. Matar had came into, New York State as a visitor. He's now a resident, and he has 25 years plus whatever credits he has already received for the time, that he has been incarcerated since this event. We're closing in on 3 years shortly. He will receive credits for good time. For there's all kinds of opportunities that are available in the state corrections system that might mitigate the sentence, administratively outside of the courtroom. And I hope that he utilizes that time because I recognize at my age that when he gets out, he'll be younger than I am now, and he'll have a fairly full life ahead of him, and hopefully he'll reconsider his value system in light of what's occurred here. It's a tragedy. It's a tragedy that anyone should resort to this level of violence. It's a tragedy that all of this occurred. It's a horrific event that despite what Mr. Barone argued in the courtroom, which I think was very effective, and I think it was a good argument. Mr. Matar controlled all of this, including the selection, not just of the venue and the subject matter that was occurring at that time, but of his intended target, and all of that swings both ways. So, unfortunately, again, while it's difficult for us, certainly it was difficult for Mr. Barone and his group, and I think they did a good job, and I want to acknowledge that. The only other thing I want to say to you is that, I want to acknowledge Mr. Rushdie and Mr. Reese. They have both undergone, a traumatic event in their lives. And I do want to acknowledge those people on the stage, both employees of the institution and just visitors who rushed to the stage at their own peril and, considerable personal safety risks to stop this attack before the completion of the act and to save Mr. Rushdie's life. But for their interaction, I think the evidence is clear that Mr. Rushdie would have bled out from about 15 holes that were inflicted upon his torso and his neck and his face right there on the stage in front of everyone who was there to watch it. And I would say something else, and I said it in the courtroom. I had asked the judge rhetorically to consider, in his 50-some-odd years of life, any horrific events he's witnessed, and I ask each and every one of you to consider that too. I can look back on seemingly innocent. I recall, watching a car accident, watching certain things that stay with me 50 years later, and I am certain in my mind that those individuals that were present when this occurred and witnessed it are impacted by this. And yes, I did refer to them as victims because they didn't ask for this, and they will live with this for the rest of their lives. And those that were closer to the stage will probably have a much harder time than those that were seated in the back. Those that actually were on the stage or came out upon the stage, including some very brave individuals, they're going to have to deal with this for the rest of their lives. So this sentence does hopefully take into account them as well, and hopefully they can start the healing process along with Mr. Rushdie and Mr. Reese. And with that,
procedural question, if you might.
Yeah.
On a determinate sentence, it's been a little while for me. Not that I've had one, but on a determinate sentence in New York State, can you still get out after 6/7? Is that still the case?
Essentially, yes. There are all types of credits available in the system. We should note that the system limits the availability of credits that might be taken advantage of by an incarcerated individual when that person has been convicted of a violent felony act rather than a nonviolent act such as drugs or something else.
But the 6/7 is still an
Essentially, yes. You know.
What do you think about Mr. Matar's speech at the end? And I didn't hear him say, "I'm sorry," or "I regret what he did." What do you think about that?
Yeah, I think he was trying to thread a needle that was, you know, because in his speech, he, in effect, you know, was providing the motive evidence that that his counsel was saying was lacking here. And I understand why Mr. Barone asserted that. And I think that was, you know, good for him for saying that. He was doing his job very well. What more can I say? There's an irony to all of this, right? I mean, his value system is that he can impose his own sense of justice and sentencing upon somebody who violates, you know, his value system, and that was problematic.
The case, as you said, has been going on for a long time. Does the sentencing sort of bring a sense of closure, not only to the victims of the case, but to you guys as well, and why?
Sure. You know, there are post-conviction remedies that are available to this defense counsel, and they've indicated that they intend to aggressively pursue those. And so, although we move into a different stage, it's quite a different situation for us. As I've lamented about so many times, we have some very difficult hurdles to overcome because we simply don't have the assets or the resources to do our jobs easily in compliance with New York State's discovery laws, which were dramatically changed a few years back. And unfortunately, they have overshadowed this case. So now that we've gotten to this point, the two areas that I was most concerned about getting in through the trial is potential prejudice opportunities that might derail us again. And then certainly discovery compliance, which is always just a very difficult thing for a small prosecutorial office.
Did you wish to have, or did you ever talk about Mr. Rushdie's letter being read into the record as a victim impact statement?
Well, when you say read into the record, it is part of the record. The record will include whatever's stated in the courtroom and also any written submissions that are filed in connection with the action. So Mr. Rushdie's statement is included in the pre-sentence investigation report. But why didn't I? I'm sorry?
But that's not part of the public record, right?
Well, it's not part of the public record because by statute, the pre-sentence investigation report is a sealed document.
Right.
However, it is part of the record of this proceeding, which will travel with Mr. Matar as he goes into the system. Now, I could have read into the record, and I thought about it, and I actually didn't anticipate the lengthy conversation, which I thought was a good conversation, a healthy conversation between Mr. Barone and Judge Foley. I was trying to, you know, to get past some of the more obvious and self-evident points is, you know, obviously we have two individuals that are in their mid to late 70s who were stabbed. You know, Mr. Rushdie was stabbed about 15 times and Mr. Reese was injured himself. So I could have gotten into Mr. Rushdie's letter as he described the trauma, you know, that he had undergone. I would say that essentially most of what he conveyed was reflected in his courtroom testimony, but in the courtroom testimony, he was obviously precluded because it's irrelevant from getting into the, you know, the post-traumatic stress that he has endured since then.
Well, what do you have to say, if you don't mind?
You know, what I would essentially say is he's going to he's traumatized, that he has nightmares about what, you know, what he experienced. I would say that on behalf of Mr. Rushdie, whether it was in his letter or not, that obviously this is a major setback for an individual that was starting to emerge in his very later years of life into society after going into hiding after the fatwa had occurred. And here he was without a security detail or, you know, and he was at his most vulnerable. And this is when he was attacked, and unfortunately, you know, this sets him back. What are we talking about? The fatwa issued in 1989, so about, 40 years? So it sets him back quite a bit, you know, and it's unfortunate. This is not a way to go into the later years of your life. Anything else? Otherwise, I appreciate, I appreciate it.
Involved at all in the federal case, or no?
I'm sorry, what about
Are you involved in the federal charges?
No. No.
Jason, could you just, for the record, just break down what the sentence for us today on both charges.
Yeah, so the attempted murder in the second-degree conviction, which is in New York State is considered a Class B violent felony. The maximum, I think the minimum offhand, if you have no criminal record whatsoever, is somewhere in the neighborhood of 5 years, and together with some parole time afterwards. The maximum is 25 years with 5 years of post-release supervision or parole, and that was what the judge had sentenced Mr. Matar to. On the assault second conviction, which is a Class D violent felony, the maximum is 7 years plus, I think, 3 years of 3.5 or 3 years of post-release supervision. And in that situation, Mr. Matar was sentenced to that as well. Then there was the issue of whether those sentences could be run concurrent or consecutive to one another, and the law is pretty clear that because all of this arose from essentially one transaction or one event, that it has to, by statute, run concurrently, and so those two sentences have merged into one concurrent sentence of 25 plus 5.
Is there a message to the community at all who is, here in Chautauqua County that's been watching over these past almost 3 years, that's kind of endured this trial as well?
It's just that we have now closed it out as best as we could. It continues in the background, and hopefully we can all just resume normalcy here. We are, I would note, we're going into another season for the institution, and hopefully we can put this behind us and just move forward. Thank you very much for all your time.
Well, I figured I'd hang around and hear what Mr. Schmidt had to say and just briefly meet with all of you, and thanks for being here today. The one thing I did want to address very briefly is what we intend on doing at this point regarding the convictions and the sentencing. So in New York State, subsequent to any conviction, or either by trial or by plea, and after that individual's been sentenced, the defense can, and in this case we will, file what's referred to as a notice of appeal. The notice of appeal has to be filed within 30 days of the date of sentencing. We intend on filing that probably today, because we're all set to go. It's a very brief document, only a couple pages long, and that's filed with the New York State Appellate Division, 4th Department, which is based in Rochester, New York. So that'll be taken care of, and then what we'll do is pursue that particular appeal and address a number of different issues which we believe the defense are certainly arguable or should be looked at by the appellate division. And just to refresh your memory on appeals, there's no new evidence, there's no new arguments made on trial, any trial arguments made, but what you have the opportunity to do is get a complete transcript of everything that was said in that courtroom from beginning to end today. And you get the transcript and you file it with the appellate division along with your brief or your argument, arguing why either something went wrong during trial or a decision was made by the court that we believe was wrong, or something the district attorney did that was wrong. In any regard, we're going to pursue that vigorously and make sure that that gets filed. In regard to the federal charges, I represent Mr. Matar federally in the Western District of New York. Actually, that particular case is, we're filing some pretrial motions within the next week to 2 weeks. requesting certain suppression hearings, addressing a number of different issues. And the volume of discovery is massive in that because, of course, it involves not only activity here in this particular country, but also involves the interviewing of witnesses and certain information that may or may not have occurred outside the country. So there's a number of different federal agencies, local agencies, and so it's a very complex situation. And the nature of the charges, of course, is very different than what was filed here in this county. So there's still a number of things that are pending and still going on. And that's one of the tightropes you have to walk as defense counsel, is what occurs between those two cases. And you just have to be very conscious of the difficulties we still have ahead of us. But at this point, we didn't, quite frankly, I mean, you always hope. I tell every client, you can't ever give up hope, no matter what it is. If you don't have hope, you don't have anything. And so certainly that's something that I honestly believed in when we took this case, and when I addressed the court today, what I discussed with the court was from the heart. And quite frankly, we had an uphill battle from the very beginning. Don't make any mistake about that. You look for a level playing field. That's all you can ask for. But unfortunately, it doesn't happen. And if anyone thinks that it does, I disagree. It doesn't. I mean, there are a number of different things. When you look back at jury selection, I don't even think there was a Muslim in the jury pool. Are you kidding me? I mean, who could have, it goes, I'm not going to get into that, but the point is that it's a very difficult process trying these cases in certain counties throughout, in more remote areas. So,
Mr. Barone, wasn't it most difficult because your client stabbed someone in front of 1,400 people?
well, yeah, I'm not arguing against that, but there's still the presumption of innocence. So if you take your argument, why even try the case, right?
I'm just saying that
Well,
had to
no,
be the
the-
most difficult hurdle, wouldn't it not be?
Oh,
that
of
you
course
put
it
eyes
is.
on this one?
Of course it is. We discussed that from the very beginning. We discussed it from the very beginning. But then when you add to that mixture, the federal charges, then there's other issues that have to be considered.
You brought up in court today assaults against your client.
Yes.
Is part of that due to the notoriety that he's now gained?
I really don't know. It's something we saw in the PSI. We're investigating it. At least initially, we've learned that, and again, I can't say this for sure, but initially we don't believe so, but that's something that we're taking a look at.
Were you listening when the DA was saying he kind of thought they didn't bring, you had made motions not to bring in motivational evidence, and then they didn't, and you kind of threw that back in his face today?
Well, the reason why it was raised today was really based on what Mr. Schmidt had argued when he gave his statement to the court and made reference about certain things he was asking the court to take into consideration when considering what an appropriate sentence would be. And that's when he talked about, the reasons why he came here. And, some of that, the things that may or may not have occurred prior to him showing up at Chautauqua. So that's really the reason why I threw that back in his face today, because if you think back to the time of the trial, there was no testimony or evidence submitted as to motive. And even preparation, quite frankly, and I like anything else, you can't get around the fact that Obviously, he was living in New Jersey, and they had admitted certain things regarding his driver's license and other information. But, yeah, so, you know, I just didn't want the court making using the court's speculation as to why he showed up here or what his reasons were for what he did.
You seemed most impassioned when they tried to suggest that there weren't just 2 victims, there were 1,400 who were traumatized, and your point being, whether
Yeah.
that's true or not, you never had any evidence of that.
No, I mean, there was absolutely nothing. And then to raise that on the day of sentencing, I think is inappropriate. It's improper, and quite frankly, there's nothing to base that on. I mean, that's pure speculation. There was no reference to any of those particular victims, no evidence or even reference to the district attorney's office interviewing those people, talking to them, medical records, psychiatric records, emotional record, any of that. So where's the trauma, you know, that's at least in my opinion, way out of line, so.
Yeah, just back to a couple of basic things. How surprised were you by the sentence, your reaction to that, and given the federal charge, does this really provide a sense of closure for you in your office, or you just move on to the next phase?
I just move on to the next phase. But I will tell you, you know, geez, I don't know. This is kind of a tough answer. You take a lot of cases, and you know from the beginning, you've got your work cut out for you. And you know that probably things are going to be very difficult. But it shouldn't deter any criminal defense attorney from taking a case. How you handle the case, it could be something entirely different. But when we got the sentence today, I was hoping for the best, expecting the worst. And does the 25 years surprise me? No. Unfortunately. But I think, and this goes back to what I argued today, was that from the very beginning, I think that, you know, society in a lot of ways determined. Outside of that criminal justice system, it was the public and society that determined what was going to happen. And unfortunately, you can try to insulate yourself as much as you want, whether you're the court or the district attorney, but you're in elected positions. You're under a microscope. And a lot of times you end up doing what you think they want to hear. And, you know, and that's, I think every case is different, you know, and I'm not going to pretend to know what justice is on a case, but you know, a lot of times you can feel the injustice in a case, and I certainly think that with certain situations, you know, you got to insulate yourself from what the public is expecting or what they think is right or what's wrong. It's, you know, and who's better to judge than the judge himself? He sat through the whole trial. He listened to the testimony. He listened to the evidence or the lack of evidence. He was able to make that determination. He saw our sentencing memorandum and what issues were raised. We had a mitigation expert come in from the state and do that mitigation report. So there was a lot of issues in front of the judge. And most notably, you know, look at when we're pre-trying this case and the court is discussing the possibility of capping a determinate sentence at perhaps 18 years. Well, it may not seem like much, but it's less than the 25 that the court gave today. So obviously, I don't know what he may have heard during trial, but there was no motive evidence during trial. There was nothing new introduced at the time of trial that, in our opinion, would warrant an increase in that sentence.
You think maybe he heard it today from Matar himself,
Yeah, I mean, you can tell your clients sometimes everything that you think they should say or shouldn't say, and you know, sometimes they listen to you, sometimes they don't. But I think that, you know, that's something that, well, I can't comment about that, but that certainly could have been something that the judge took into consideration today.
Did you expect Mr. Matar to speak prior to sentencing today, and why did he decide to speak?
I thought that it's something he felt compelled to do after listening to the court and listening to some of the arguments made by Mr. Schmidt about certain things. So I think that at least what I gathered was that it's something he felt compelled to talk about. And I indicated, and I think it's something that he's got a very strong religious belief, and he adhered to his religious beliefs while he's been incarcerated. He's asked for certain accommodations, and he's received those. So I think that there were certain things that he felt compelled to say.
So it was a game time decision?
Yeah, pretty much.
Yeah, so he decided while listening to Mr. Schmidt today.
What did you get? I mean, I can't speak to him right now. You're speaking for him, I guess. And what was he getting at there? What do you think he was getting at there?
Well, I think that my opinion, personal opinion, is that he was trying to let the court know that, look, it's this was you know, he felt very strongly about his Muslim religion, number one, that it's something that's extremely important to him, and I don't doubt that. But secondly, I think that it's something, you know, he may have taken a look at different authors or different individuals talking about the freedoms of expression or the freedom of religion, and what certain groups practice or don't practice, and then getting into the issue about Mr. Rushdie and what he considered his actions being, and that's disrespectful. And I think that he probably spoke, I mean, it's something I think that we saw a little bit of that after the incident. I think that you saw a couple different groups come out of the woodwork a little bit, at least from our end. You saw some Muslim Shiites that would say, look, what happened is wrong, doesn't matter. Then you saw another faction or group that came out and said, look, you know, Mr. Rushdie was being disrespectful to our religion. And as a result, we understand why this happened.
But does he regret doing this?
Pardon me?
Does your client regret?
Oh, yeah,
Any remorse from you?
pardon
Any
me?
remorse?
I think that's the same question.
Well, yeah, I think that's a fair question, and I can't answer that. Look, personally, I've never had any issues with Mr. Matar from the very beginning, and we've had a great relationship. We've discussed a lot of different things, and I know if he had the opportunity, he would not be sitting where he's sitting today, and if he could change things, he would. So all I can tell you is that I think that, you know, unfortunately, people make bad decisions, and it's something that certainly they regret or they're remorseful about, but they may have a difficult time expressing that for whatever reasons, you know, and I can't tell you why or why not, but I can't tell you that. I wish I could.
Now, do you have a timeline for the federal charges?
Yeah, I just got a scheduling order. I think we have to have everything filed in a couple weeks, and the U.S. Attorney has approximately 30 days to respond, which brings us into January. I think we have a court appearance sometime in July to to talk about the hearings that will be necessary and going from there.
When do you picture going to trial?
You'd probably be looking at sometime next year. Maybe the end of this year, maybe. But we'll see. Okay? Thank you. Have a great day.
You too, thanks.
Yes, thank you. Thank you.